Philippines is going to buy green. Our government is taking the lead. The Philippines Green Public Procurement Roadmap guides the way forward by considering local business capacities, climate, environment, health, and value for money. Our government procures thousands of items every year to serve the Filipino people. When government is the single largest buyer in a market, its procurement decisions influence the direction that businesses take. Green public procurement is about buying products which are low carbon, are healthier, avoid harmful chemicals, and are manufactured through cleaner processes. They are efficient to use and consume less energy and water. At the end of life, precious materials are recycled. GPP reduces the pressure on the environment. GPP is a partnership between the government and businesses. GPP opens up new, exciting, and reliable opportunities for businesses supplying green products. This in turn makes green products also affordable for private households. A first batch of 20 product categories has been prioritized for GPP, and more will be selected over time. The priority common supplies and equipment products are multi-copy paper, toilet paper, record books, cleaners, chairs, disinfectant sprays, trash bags, liquid hand soap, detergent powder, and LED lights and bulbs. The priority non-common supplies and equipment products are computer and laptop monitors, air conditioners, vehicles, fridges and freezers, copiers, paints and varnishes, food and catering services, training hotels and facilities, toilets and urinals, and textiles such as uniforms and work clothes. The well-established public procurement processes in the Philippines, such as the PhilJobs, will ensure fairness, transparency, and open competition for the green venture. Everyone can become an active consumer of green products, which save energy and water, are not harmful for health and climate, and which are recyclable.
Do you know that procurement is crucial in achieving our society's collective vision of a strongly rooted, comfortable, and secure life in the Philippines? Hello everyone, I'm Billy Bayong. Let me show you how our Procurement Policy Board innovates, adapts, and responds to our changing needs to enhance the procurement system and help the government work for us. An efficient, transparent, and competitive procurement system connects every Filipino to vital services from the government. This can help move more people out of poverty, gain access to better education, receive quality healthcare, and enjoy economic opportunities. These yield greater trust in government institutions and bring the country closer to achieving its national development goals. The Government Procurement Policy Board focuses on simplifying various processes to produce more successful procurement that contributes to the effectiveness and efficiency of the government. The board employs strategies to identify needs and implement projects. It refines and calibrates procurement policies, adjusting to emerging trends based on needs of procuring entities. It creates ways to capacitate practitioners to better manage their procurement processes, monitor effectiveness of our procurement systems, and it adapts to the times, especially during national emergencies. The GPPB has strengthened the procurement process at the earliest stage, the planning phase. The board has issued bidding rules responsive to new laws and policies set by the government. GPPB has also streamlined the bidding process through the use of technology. GPPB has introduced guidelines to ensure timely procurement, especially during a national emergency. GPPB Technical Support Office pioneered initiatives to better assist procuring entities. simple and competitive, transparent and accountable, monitored by the people. These make for an effective procurement system, responsive to the needs of the people. The GPPB, adapting, responding, innovating for nation building. To know more about procurement, visit gppb.gov.ph.
Okay, so thank God it's Friday. Good morning, everyone. I am Jen Aguilar from the Capacity Development Division, and I welcome you all to the fourth day of our online training for the Municipal Local Government Units on Government Procurement Reform Act, or the Republic Act 9184 and its 2016 revised implementing rules and regulations, brought to you by none other than the Government Procurement Policy Board Technical Support Office. So before we start, may I ask first our Zoom participants to change their name using the required format, and it is your municipality name underscore your full name for us to properly identify and monitor your attendance to this virtual event. Also, in order to maintain clarity and be able to properly manage the time, microphones shall be muted throughout the entire session. So today, to start our program, may I request everyone to put ourselves in the most mighty and holy presence of our Lord Jesus Christ. Okay, loving Heavenly Father, we come to you this hour asking for your blessing and help us as we gather together. We pray for guidance in the matters at hand and ask that you would clearly show us how to conduct our work with a spirit of joy and enthusiasm. Give us the desire to find ways to excel in our work. Help us to work together and encourage each other to excellence. We ask that we would challenge each other to reach higher and farther to be the best we can be. We ask this in the name of the Lord Jesus Christ. Amen. So once again, happy Friday morning to everyone. So ito na po yung last day of the week natin. So before we dive into our lecture proper, we prepare a short energizer for today's program. So today we will be having the Guess the Movie title. So the game mechanic is very simple. So we will be flashing onto our screen original Filipino movie clips, and all you have to do is to guess the movie title in 5 seconds. Okay, for our Facebook and YouTube live viewers, good morning po. And also you may participate by dropping down your answers or the title of the movie to our comment section. So for the first movie, we have okay, let's check. So we have from LGU Kabugao, Sir Ronnie, his anak. Any more guess? Inaantok po yung ating mga participants. So any more? So let us show the correct answer. So we have anak. Ayan. So sana dun sa second movie clip, marami pang mag-participate na participants, no, para we can check kung alam natin yung mga Filipino-owned movies natin. Sige, for the next movie clip, we have aba, from LGU Kabugao ulit, si Sir Ronnie, one more time. Ano kaya yung guess ng mga iba nating participants? So let's check kung meron nagsasagot through our Facebook page, no? Okay, so let's reveal the answer, please. So we have one more try. So starring Angel Locsin and Angelica Panganiban. So next. Ito very iconic movie to. So sino kaya yung makakahula for this movie? Naku, wala pa din. So let's check kung anong movie ito. So let's reveal the answer. So ito yung very iconic movie natin na Between Walang Ningning. So starring Sharon Cuneta and si Miss Cherry Hill. Okay? Meron pa po ba? May next pa ba tayong movie clip? Okay? So this movie is one of the most watched movies rin before. So starring John Lloyd Cruz and Bea Alonso. Okay? So let's see. Okay, let's reveal the answer in 5, 4, 3, 2, 1. Okay, the answer is One More Chance. Tama na naman po si Sir Ronnie. Mukhang mahilig si Sir Ronnie manood ng mga Tagalog movies. So I think this is the last movie. So let's check. So this movie starring Jolina Magdangal and Marvin Agustin. So isa sila sa mga tinatangkilik na love team noon. So yung mga kabataan nila. Sino kaya yung mga nakaabot nitong movies na to? So let's check. What is the title for this movie? 5, 4, 3, 2, and 1. Okay, so the correct answer is Loves Kita, Okay Ka Lang. Okay, thank you very much po sa lahat na nag-participate. So at this point, before we shift to the actual lecture proper as promised, let us first have our early bird winners for today. So congratulations to our early bird participants from the Municipality of Tantarat, Mr. Arnold M. Balani Jr. Congratulations po. And to our second early bird participants from Municipality of Sipalay, Negros Occidental, Mr. Ronnie T. Tababa. So congratulations po once again, and our events secretariat shall coordinate with you on how you may claim your special token. So also for the winners of our yesterday's program and the other winners from day one, please do check your emails or chat box and kindly revert back with the details for us to ship your respective tokens. So now, before we go ahead to the lecture proper, here is a quick recap of yesterday's learning session. So yesterday, we had an entire session on alternative methods of procurement, where we had an extensive discussion on the various alternative methods which may be utilized in government undertakings and its appropriate use based on the prescribed conditions, procedures, and documentary requirements led by our resource speaker, Ma'am Annabel M. Atilio. So before anything else, we would like to remind our Zoom participants again that our fourth learning session module on standard bidding procedures for goods, infrastructure projects, and consulting services will be held on August 30, Tuesday. So please make yourselves available on August 30 because we assure you that most of your concerns or questions on the conduct of bidding activities shall be addressed in this module. So today, we will be having 2 full sessions on protest mechanisms and remedies and on blacklisting guidelines. respectively. So without further ado, it is with great pleasure to introduce to you today's learning session's resource speaker. So our resource speaker graduated BS Agriculture, major in agronomy at Javier University, also known as Ateneo de Cagayan at Cagayan de Oro City. Bachelor of Laws Bachelor of Laws at the Father Saturnino Urios University at Butuan City, and had his Master of Dispute Resolution at University of Technology, Sydney, Australia. He was a former professor on labor code and local governance, local government operation officer, and attorney for at DILG Caraga Regional Office. Currently, he is an instructor in remedial law review, civil procedure, intellectual property law, and alternative dispute resolution at the College of Law of Father Saturnino Urios University, Butuan City. So, ladies and gentlemen, let us welcome Acting Presiding Judge at the Municipal Trial Courts of Buena Vista, Agusan del Norte, Cabadbaran City, and Tubay, Agusan del Norte, and a GPPB recognized trainer, Attorney Anthony P. Vitor. Attorney Anthony, the floor is now yours.
Good morning, participants to this online training on Government Procurement Reform Act or the Republic Act 9184 and its revised implementing rules and regulations, especially to the participants from the different municipal local government units of the country. So I am your resource person for today. I am Anthony Vitor, and I am discussing to you three topics for today. It's about penal, civil, and administrative liabilities, termination of contracts, and protest and blacklisting mechanism. So I'm now sharing my slide and discuss first the penal and civil liability. Okay. So as we know, if we government officers or public officials committed criminal act, we are liable where we what we call a threefold liability. We are liable civilly, criminally, and administratively. No, that is for us, the public officers. So the standard of ethics in procurement is required to be observed by all participants in the procurement process and up to the execution of the contract. So it should be observed by the procuring entities, specifically in this particular training, the local government units, the bidders, manufacturers, suppliers, or distributors during the procurement and execution of contracts, and any bidders who have committed corrupt, fraudulent, collusive, and coercive practices by the government will not be eligible to bid in its project. So there are four unlawful acts. Coercive practice, meaning threatening to harm the other person in order to influence the outcome of the bidding. Collusion, again, the two or more persons agree to make any arrangement, whatever, to have the bidding be favorable to this particular bidder or disadvantageous to this particular bidder. Then corrupt practices, of course, the giving of consideration, whether in kind, money, or whatever, to a certain person involved in the procurement, in order to again influence the outcome of the bidding. Fraudulent practice when when a person or the bidder for any person involved in procurement would make a mispresentation of documents, again to influence the outcome of the bidding. So what are the penal provisions? The Republic Act 9184 states that it is without any criminal act committed in violation of 9184, it is without prejudice to the provision of RA Republic Act 3019 or Anti-Graft and Corrupt Practices Act. Meaning, if you committed a criminal act in violation of 9184, for as long as the elements are also present in violation of RA 3019, then you are, or a person who committed an act in violation of 9184 maybe also be liable under RA 3019 or liable under criminal law or revised penal code pertaining to bribery, direct bribery, or indirect bribery. Okay, so it is without prejudice, no? So meaning, it's because I violated only 9184. No. Even if you are already criminally charged for violating RA 9184, you may still liable under RA 3019 for as long as the elements of RA 3019 or provisions of that RA 3019 is present. Okay. So who are those liable? So liable are those public officers who committed any of the acts enumerated under section 65.1 of the IRR, and the private individuals who collude with the public officers. With regards to 65.2 and 65.3, or violations of sections 65.2 and 65.3, it is committed by private individuals. But the public officers who conspires with the private individuals are also liable. So in both instances, whether you are public officers in collusion with private officials or private officials or private individuals in collusion with public officers, liable pa rin. Okay. So this covers all types of procurement, whether done it is manually or electronically, no? Because we're already allowed to because of pandemic, COVID-19 pandemic, we are already allowed to conduct procurement electronically. However, pertaining to criminal liability, no, if when the bidder is a juridical entity, a criminal liability and its accessory penalty shall be imposed on its directors, officers, employees who actually commit any of those acts under section 62 or section 63, section 65, who actually committed any of the foregoing acts. No? So if it is a corporation or cooperative, then it is the person who actually committed any of the foregoing acts are or is liable. Diba? Of course naman, the personal liability yan dahil you cannot imprison a juridical entity. You cannot imprison a corporation. You cannot imprison a cooperative. You can put in prison only the person. So it's not juridical entity. No. So because you cannot imprison a corporation. Only the person or officers, employees who actually committed any of the foregoing acts. So we'll discuss what are those foregoing acts. So if a person previously held liable or found guilty under the provisions of this Act and this IRR has a controlling interest in a prospective bidder entity, the said bidder entity shall be disqualified to participate in any procurement activity being conducted by the government. So if this particular person has a controlling interest of Corporation A, 20%, he owns 20% of the shares of that particular corporation, a blacklisted. So if there is also Corporation B, in which this person who has controlling interest in Corporation A has also a controlling interest in Corporation B, that Corporation B is also disqualified or blacklisted to participate in any procurement activity. So that's it. So there must be a controlling interest, which it's 20%, at least 20% of the controlling shares is owned by that particular person. Okay. So what are the penalty? What's the penalty in case of imprisonment? So the imprisonment is 6 years and 1 day, but not more than 15 years. So the imprisonment is 6 years and 1 day to 15 years. So there is no, because this is special law, there is no opportunity to apply for provision, because provision is only applicable if the penalty imposed is not more than 6 years. No? So 6 years. So provision is not available if you committed this particular offense. Maybe if during the trial you apply for plea bargaining and you will apply to play on another law, or the same, no, which has lower penalty, then you may, but it depends on the court whether to grant, or depends on the prosecution, the parties to grant, whether to grant the plea. Okay. So with regards to public officials, so penalty, it's an accessory penalty, no? So aside from 6 years and 1 day imprisonment, but not more than 15 years, accessory penalties, temporary or perpetual disqualification from public office. So temporary disqualification is during the period of imprisonment, you are not allowed, you are prohibited from whether elected the appointment position in the government. That is temporary. Perpetual disqualification, of course, whether you're already released from prison because you already served the sentence, or because of good conduct allowance, your imprisonment is shortened, then you can be appointed or elected in a public office. That is for temporary disqualification. But perpetual meaning hanggang mamatay, wala na pong opportunity to be in the public office. With regards to private individual, diba, juridical, because what can be imprisoned for juridical entities only the person who actually committed the offense. So that person who committed the offense, because he's the one who is already imprisoned, then that person is permanently disqualified from transacting business with the government. So that person is what? Blacklisted already, disqualified. Okay. Jurisdiction over the offenses defined under this rule shall belong to the appropriate courts according to the laws existing at the time of the commission of the offenses. So remember, it's 6 years and 1 day to 15 years. So in this particular case, if the offense is in violation of 9184, it should be filed before the regional trial court. Because the regional trial court has jurisdiction of any offenses in which the imposable penalty is at least 6 years and 1 day. But if the person who committed the offense, the principal, especially the principal, has a salary grade of at least 27, then it should be filed before the Sandigan Bayan. No. Under the law creating the Sandigan Bayan, even if you do not belong to SG 27, you are still the Sandigan Bayan has still jurisdiction if, especially in the local government units, if you are a provincial governor, provincial vice governor, sangguniang panlalawigan, and head of offices of the provincial head departments, provincial engineer, whatever, and also to the city mayor, city vice mayor, sangguniang panglungsod, and city department heads. So their cases should be filed before the Sandigan Bayan. No. But even if you're not included in this particular enumeration of the law creating the Sandigan Bayan, if one of your principal, if the principal, or one of the accused the case against one of the accused is filed before the Sandigan Bayan because it's covered under that law, no? So those persons receiving or not within SG, pero kasama kayo sa act, then your case should be filed before the Sandigan Bayan. So just like example sa LGU, the Bids and Awards Committee, what is required is only the third level should be the chair of the BAC. But the members of the BAC, it is not required. Diba? Kailangan office, sinasabi lang, from the office of the budget, city budget office. So anybody in the budget office can be a member of the BAC, not necessarily the budget officer. So of course, that person has a salary grade of less than the department head. But since accused kayo lahat as BAC, yung head ng BAC third level sa city, or kasama yung city mayor, then lahat yan Sandigan Bayan. Okay. Hindi pwede yung si mayor lang ang Sandigan Bayan, si city head department lang ang Sandigan Bayan dahil ako I belong to the salary grade below 27 or below that of the department head. A case should be filed against me before the regional trial court. Doon sila lahat sa Sandigan Bayan. Committed of 9184. First is to bids that may have been submitted through electronic system. No. So kahit pa electronic system, electronic yung pagpadala ng bid, no? Kailangang dahil yung open naman ng bid sa electronic, dapat may mga password. Okay. Now, kung i-open mo yan or you receive open documents, then you are liable. So kung open documents kasi na nasubmit sa inyo, naka-open yun, do not accept. No? Secretariat, do not accept. Let the bidder or the one who submitted the bid docs to seal the bid. Do not touch, do not accept. Now, if it is improperly sealed, no, na-seal po siya, but not full or improper, no, then you can accept that, but they have to notify the one who submitted the documents, no, that this document is improperly sealed, no. Nakasilyo siya pero naka-seal pero may mga problema lang, pero di mo rin ma-open, no. So dahil if you accepted an open bid, or you accepted or you open it, then you are liable, Secretariat, you're liable under this law, no. So do not open. Then second, delaying without justifiable cause, the screening for eligibility, opening of bids, evaluation and post-evaluation of bids and award of contracts beyond the prescribed periods of action. So, di ba sa pag-post ng invitation to bid or yung sa consultancy, nakasad na doon when to open the bid, when to screen eligibility, when to post-eval and award of contracts beyond the prescribed period, di ba? May mga dapat this number of days lang may award ng contracts na. That is without justifiable cause, no. So you are liable, back members liable under Section 65A of RA 9184. But nakasad naman dito without justifiable cause. Example, kung yung schedule of bidding mo is schedule of opening of the bids or screening of eligibility naka-schedule, lindol, may typhoon, just like what we are experiencing in Manila. Okay. May typhoon, nag-declare ang president, walang pasok, nagkataon yun ng opening of the bids. Syempre, you have to cancel your opening of the bids because the delay is justifiable. So may justifiable cause yan. So pwede yan, you are not liable. No? Ang ano lang dito, without justifiable cause. Then, next is undue influencing or exerting pressure on any member of the BAC or any officer or employee of the procuring entity. So unduly influencing or exerting undue pressure. No? Example, may mga ano tayo, example, especially sa LGU, di ba? Yung mga ano, member. Example, mga member doon hindi pa promotable. Okay, sabi ng mayor, sabi ng back chair, dapat gawin mo to, dapat ganito, dapat ito yung mananalo, dapat dito ma-award sa ganito na bidder. Dahil kung hindi mo, you will not follow my instruction, remember, Mr. Back Member, Mr. Back Chair, you are promotable, your appointment is ready in my desk, and you know, if you will not follow my instruction, or I may not appoint you, I will not promote you. So that is unduly influencing or undue pressure, or exerting undue pressure. Then, splitting of contracts. Well, splitting of contracts, the purpose is to avoid competitive bidding. Avoid competitive bidding. So example, nandoon na yung budget. The budget is more than 1 million, example, or then it is under competitive bidding, or you want, even it is 500,000, but competitive bidding, or example, 2 million should be under competitive bidding, but you would split that so that pwede ka nang magpunta doon sa small value procurement. Okay, diba? Okay, municipalities up to 200,000. Okay, example sa munisipyo, mga municipalities may 1 million, you want to split that in order to conduct small value procurement. Maximum is 200,000. Okay. So, yeah, 200,000 ba? Tingnan natin. 200,000. So, you want to split that into less than 200,000 so that you can conduct a small value procurement. Okay. Dapat to multi-purpose building una ang you have to establish first or construct first the roofing. Okay, that is another RFQ because you're conducting a small value procurement. Then another is concreting of the floor. That's another small value. No, so that is splitting because the budget is already there. But with regards to something like by parcel, I mean, ano ba yung tawag na yun? Lot A or lot 1, lot 2. Okay. You can do that, no? Because based on your market study, no entity or bidder can supply all of this. So, example, this particular machine can only be supplied. Example, machine A, B, C. No, based on your study, no person, no entity can bid all three, can supply all the three. So only some can supply A, machine A, some can supply machine B, some can supply machine C. So what we will do is to bid it by lot. No, lot 1 for machine A, lot 2 for machine B, lot 3 for machine C. So you can do that. No? Because based on your market study, failure pa rin kung yung tatlong machine ibibid mo as one, eh magka-failure pa rin because no one can supply that. So, in-split mo. A, B, C. You can do that. No? You can do that. In the head of the agency abuses the exercise its power to reject any and all bids. Di ba? Sa invitation to bid, may ano doon, may reservation clause. The reservation clause is ito. The head of the procuring entity has the right to reject any and all bids. No? So, kung i-reject kasi, no, dapat may reason. Ba't ni-reject mo? No? Hindi pwede, I don't reject that. Or example, you found out that the PAC did not or abused its power and did not, the bidding was not in accordance with the law or the IRR of 9184. So, you have to you can reject that. Or the the observer notifies you or notified you in writing that there's some anomaly in the conduct of the bidding. No, so you can reject the bid. No, so do not abuse. If you abuses that power, then the head, especially the head of the procuring entity, be liable under section 65A. Okay, for private individuals, no, again, public officers conspiring with the private individuals are also liable under their disprovision. Okay, so section 65B of RA 9194. But the principal what's this liable is the private individual. No? Again, including the public officer. So first agreement and submission to submit bids with pre-arranged lowest bid. Okay. So yung mga private bidders, okay, bidder A, bidder A, bidder B, bidder C. Okay. Mag-ano tayo? Mag-arrange tayo. Ako lang munang mananalo. Taasan nyo yung mga bid price ninyo. Okay. Dapat ako lang mananalo. Ganito, bibigyan kita ng pera, di ba? May mga buyout, something like that. Okay. Then, malicious submission of different bids to through or more persons. No? Isa lang ang may-ari, pero two or more persons yung pagbibid, no? Okay. Pero isa lang may-ari ng corporation, controlling, di ba? May controlling interest, no? Para, of course, siya lang ang mananalo. Agreement to secure undue advantage, no? Okay? Employment, di ba? May kasama pang open bid. Pero yung open bid, wala yung, kung kasama yung public officer, then kasali siya dito. Now, yung iba, yung mga bidder, gano'n lang o magkano yung bid mo. Magkano yung bid mo. Okay. So, that's an agreement to secure undue advantage. Then, employment of scheme disadvantageous to the public. No? Kung ano yung mga sistema nila na disadvantage sa public. Okay, ito yung gagawin natin, ito yung gagawin natin. Ano yung mga quality lang natin. Okay, yun. Okay. So ito yun. Actually, this is only parang ano lang ito sa kanina. No? When two or more bidders agree and submit different bids as if they were bona fide, when they know that one or more of them was so much higher than the other, that it could not be honestly accepted and that the contract will be surely be awarded to the pre-arranged lowest bid. Okay. When two or more bidders into an agreement which call upon one to refrain from bidding for procurement or which call for withdrawal of bids already submitted or which are otherwise intended to secure an advantage to any one of them. Okay. Okay. Huwag kang magbibid. Ako lang, 'di ba? Pwede naman isa lang magbibid. No? Ako lang, huwag na. Or before the opening, ako lang ang sabi kasi niya, ako lang mananalo or ako lang magkano sa iyo. Withdraw mo na yung bid. Okay? So, that is again violation. Okay? Ito, when a bidder maliciously submits different bids through two or more persons, ito, in partnership or any other business entity in which he has interest to create the appearance of competition that does not in fact exist to be adjudged as the winning bidder. No? So, isa lang ang mayari. When a bidder by himself or in connivance with others employs schemes which tend to restrain the natural rivalry of the parties or operates to stifle or suppress competition and thus produce a result disadvantageous to the public. So, connivance with others schemes which tend to restrain natural rivalry. No, di ba? So, kung with in connivance with public officers, okay. And ang submission is nasa elevator, nasa 13th floor. Pagkapunta doon, dapat naka-elevator. Okay. Sasakay ka ng elevator. So, sa 14th floor. So, kung ang isang bidder at something like 8 o'clock, submit na yung honor before 8:30 in the morning, submit yung bidok. So, 8:30, nagsubmit na yung isa. In connivance with the public officers, sirain mo yung elevator para hindi sila makapunta dito honor before 8:30. So, that is advantageous to the public. Walang competition. Walang competition. So, yun ang mangyari. Okay. Submission of eligibility requirements containing false information of falsified documents or concealment of such information. Okay. Actually, this one can be found during post-qual. No? During post-qualification, you can do checking whether requirements are true or false. Then submission of e-docs containing false information or falsified documents or concealment of such information. Using name of another or allowing another to use one's name. Actually, tingnan na kung ano na, marampan dito eh. Ano lang ng royalty, gagamitin ko lang yung license mo. Ako lang subcontract. Parang ganun, subcontract pa rin. Using your license, o bibigyan lang kita ng royalty, magkano bang royalty mo? Okay, ito, ako lang. No? Ang problema kasi dyan is, kung ang trabaho is not good, no? The quality is not good. Of course, yung principal ang liable, di ba? Go withdrawal of bids without justifiable cause, no? Withdrawal of bids dahil ba't palagi kang nagwi-withdraw? I think it's thrice a year, palagi kang nagwi-withdraw. So,
red flag na yan. No, red flag. Now, question is, sinong magsusumbong? Who will complain? Especially in section ito, using name of another or allowing another to use one's name or withdrawal of bid. Okay po. Then itong sa B, sinong magsusumbong? Eh, tayo naman lahat, nakapera dyan eh. O, bibigyan kita ng pera, iba-buy out kita, ako lang magbibid, o magkano bang nagagasto mo, i-refund mo, times 2 ko.
Ako lang magbibid. Yun kang nabayaran ko na to withdraw the bid. Ano ba? Magsusumbong ba yun? I doubt. No? Ewan ko kung ang participant ba nito magsusumbong. Dahil kung if you are not a participant of this offense, of this act, how can you prove that in court? No? Eh, nagbibigayan sila. Eh, paano nagbibigayan? Yung yung mga bidders, sabi walang bigayan, walang binigay in order for me to withdraw, wala. So it's difficult to prove for me. I don't know to others if it is possible to prove in court. Well, with regards to submission of eligibility requirements or submission of false information, well, pwede sila liable dahil kita naman, dahil di ba, ang technical working group pupunta, mag-post qual, so makita nila yung documents.
Okay, thank you, Attorney Vitor. Now, as discussed again, we will be flashing series of knowledge check questions through the Zoom calling feature, and all we have to do is to choose the appropriate answers in the pop-up call that shall be flashed in our screens. So, may I ask our technical team to flash our first knowledge check question. So the question is, Republic Act number 3019 or 3019 is otherwise known as the A. Government Procurement Reform Act, B. Anti-Graft and Corrupt Practices Act, or C. Anti-Red Tape Act. So again, Republic Act number 3019 is other known as the A. Government Procurement Reform Act, B. Anti-Graft and Corrupt Practices Act and other penal laws, and C. Anti-Red Tape Act. So key in your answers using our Zoom polling feature. So for our Facebook and YouTube live viewers, again, you may participate and comment down your answers through our comment section. So let's see. Currently, we have 75%. So may hahabol pa po ba? Okay, we will be closing the Zoom in 5, 4, 3, 2, and 1. So let us share the result, please. So for the result, we have, for letter A, we have 13%. For letter B, we have 87%. And for letter C, we have 0%. So, Attorney Vitor, may we know po the correct answer?
Okay, so the correct answer is letter B. Republic Act 3019 is Anti-Graft and Corrupt Practices Act, because Government Procurement Reform Act is what we're doing now, no? Then the Anti-Red Tape Act is Republic Act 11032. No? So the correct answer, the 87% of the respondents got the correct answer.
Thank you so much po, sir. We can now proceed with our lecture.
So as I said, we are now civil. So without prejudice, again, it is says without prejudice to administrative sanctions that may be imposed in proper cases. Meaning without prejudice, meaning if there are other administrative sanctions aside from 9184, then that uh, that person, well, is also liable. Okay. In conviction under this law and RA 3019. No? So what are the liabilities? Of course, restitution for the damage done. No? So we have to refund. No? We have to pay for the damage done because of the act under violated under 1994. Then kung may mga benefit, especially dun sa corruption, no? Then forfeited in favor of the government of any unwarranted benefit derived from the act or acts in question or both at the discretion of the court. So forfeited kung anumang benefit na na-receive ng mga back members or ng private individuals because of that collusion, fraudulent act, then liable to pay or forfeited yung yan, nabili mong bahay because of that, then forfeit yan in favor of the government. The third penalty is administrative. So I said before, in every criminal act a government official committed, there are other two sanctions, civil and administrative. So let's go now to administrative sanction. Okay. So in addition to the penal and civil sanctions, the whole subject to the authority delegated to the BAC, if any, shall impose on bidders or prospective bidders the administrative penalty of suspension for 1 year for first offense, for 2 years, second offense, okay, and the succeeding offenses, 2 years. No, so they are suspended from participating in the public bidding process and disqualified from further participating in the public bidding undertaken by the procuring entity. So this is suspension. So in suspension, the bidder or the prospective bidder is not allowed to participate in the public bidding of a certain being undertaken by the procuring entity. No? So it's only the procuring entity that impose suspension in which the bidder cannot participate. In other government agencies, in other procuring entities, the bidder suspended can still participate in other bidding, in other procuring entities. Okay. Then, forfeiture of bid security, if the acts were committed prior to the award or prior to the acceptance of the award, and the performance security if after the acceptance, but then there's certification of final acceptance 1 year after from the performance after the completion of the project, especially in infra project. So the procedures for blacklisting of manufacturers, suppliers, distributors, contractors, or consultants for government projects shall be undertaken in accordance with the guidelines to be issued by GPPB. No? Okay. Now, we will discuss actually blacklisting in our in one of the topic is the protest and blacklisting. So we'll discuss blacklisting, which is part of administrative penalty. So let's go to termination of contracts. Okay. Okay. So subject to the guidelines on the termination of contracts under Annex I of the 2016 revised IRR of RA 9184. So the objective of the termination of contract is promote fairness in the termination of procurement contracts and prescribe contract conditions and measures to enable the government to protect its interests. So in the termination of contract, it is always to protect the interest of the government. Okay. GPPB issued a resolution number 07/2019. And the subject matter is approving amendments to item 3, paragraph A, subparagraph 1, subparagraph A, B, and C of Annex I of 2016 revised implementing rules. Okay. It's the general conditions of the contract, Philippine bidding documents for the procurement of goods and clauses or close or liquidate the damages of the general conditions of the contract for procurement of goods, infra projects, and consulting services. It was approved on March 8, 2019, but effective on May 9, 2019. So there are 5 grounds for the termination of contract: termination for default, termination for convenience, termination for insolvency, termination for unlawful acts, and termination by contractor or consultant. So termination by default. The procuring entity shall terminate a contract when any of the following conditions attend its implementation. Okay. If aside the force majeure, meaning it is beyond, it is due to calamities, whatever, force majeure, beyond the control of the supplier. So this supplier, outside the force majeure, the supplier fails to perform or deliver any or all of the goods wherein such failure amounts to at least 10% of the contract price. Okay. As a result of force majeure, so this is for force majeure. Okay. The supplier is unable to deliver or perform any or all of the goods wherein such failure amounts to 10% of the contract. So it's the same, 10% of the contract. But in this, if it is due to force majeure, if failure to deliver within not less than 60 days, calendar days, from receipt of notice from the procuring entity that the force majeure is deemed to have ceased. Okay, nawala na po yung force majeure. So kailangan i-deliver ng supplier within 60 days, within 60 calendar days. So for a period of not less than 60 calendar days after receipt of the notice from the procuring entity that the force majeure is deemed to have ceased. Or the supplier fails to perform any other obligation under the contract. So in this particular case, it is the procuring entity that shall terminate the contract. If outside the force majeure, failure to deliver at least 10% of the contract price. If force majeure, again, the same 10% for failure to deliver. For a period of not less than 60 calendar days after receipt of notice from the procuring entity that the force majeure is deemed to have ceased. So you have to deliver, the 10% should be delivered within 60 calendar days. After 60 calendar days, then that's a ground for termination for default. And the supplier fails to perform any other obligation under the contract. So the procuring entity shall terminate the contract. For infra projects, if it is due to the fault of the contractor while the project is ongoing, there is a negative slippage of at least 15%. So if there's a negative slippage of 15%, then the procuring entity can issue termination for default. If after the expiration of the contract time, the contractor incurred negative slippage of 10% or more due to its fault. No? So, nag-expire na yung contract, no? May negative slippage pa ang contractor ng at least 10%. Okay. In contracts for infrastructure projects, again, the contractor commits any or all of the following: abandon the contract works, refuses or fails to comply with a valid instruction of the procuring entity, or fails to proceed expeditiously and without delay despite a written notice by the procuring entity. Then there is a requirement, example, required minimum essential equipment in the project site, but upon inspection, wala doon, no? Hindi nagmi-meet ng minimum yung mga essential equipment. In accordance with the approved work plan and equipment deployment schedule. So that's another violation, no? So ito yung minimum equipment in accordance with the approved work plan and equipment. But during inspection, it was found out that kahit minimum di na-meet ng contractor. So that's also ground for the termination of default. The contractor commits any or all of the following: does not execute the works in accordance with a contract or neglects to carry out its contractual obligation. Okay. Neglects or refuses to remove materials or perform a new work that has been rejected as defective or unsuitable. Sa pan-inspection, sinasabi ng procuring entity, oh, ito, problema ito, dapat dito pwede, hindi ito the construction is not in accordance with the approved program of works, approved design. No, dapat ito palitan. And kung hindi ito papalitan ng contractor, then the procuring entity has the right to terminate the project. Okay. Sublets any part of the work without approval of the procuring entity. No, especially pa subcontract. Okay, subcontract ikaw, then ako, I will not work this project anymore. So ikaw contractor, ikaw, you will be the one to perform or complete this project. Diba? It's also a ground under criminal, civil, and administrative provisions, liability. So it's also a ground, diba? Subcontracting, especially if it is without the approval or of the procuring entity. So that's also a ground for default, termination for default. So aside from those liabilities mentioned before, the project will be terminated. For consulting services outside force majeure, the consultant fails to deliver or perform the outputs and deliverables within the period specified in the contract or within any granted extension. Or if it is a result of force majeure, the contract is unable to deliver or perform a material portion of the outputs and deliverables for a period of not less than 60 calendar days. So dapat within 60 calendar days, just like in goods, dapat within 60 calendar days, the consultant should deliver or perform the outputs and deliverables. After that, if it is more than 60 calendar days, wala pa rin, then that's the time that the procuring entity can issue termination for default. Or the consultant fails to perform any other obligation under the contract. So dapat malaman natin kung ano yung nasa kontrata, then kung may hindi na perform ng consultant, that's a ground for termination. ito, the procuring entity, ito ay termination for convenience, may terminate the contract at any time for its convenience. The hope shall determine the existence of conditions that would make the project implementation economically, financially, or technically impractical or unnecessary. So pagtingin ng project, wala na, impractical na ito na project, doon na implement na, that's termination by convenience. Of course, the contractor will be paid quantum merit, no? Based on the expenses, based on the financial the expenses that they have incurred, no? Under quantum merit. So economically, financially, or technically impractical or unnecessary. Unnecessary in the sense that there are laws. Example, there are laws that would that change the project. No? This is beyond the control of the procuring entity. Pursuant to the national laws, rules, or regulations. So that's the time that the procuring entity can terminate for convenience. Insolvency. No. The procuring entity shall terminate the contract if the supplier, contractor, or consultant is declared bankrupt or insolvent as determined with finality by the court of competent jurisdiction. Okay. Now, it is necessary to have a final declaration, final judgment of the court, no, that the supplier contractor is already insolvent. No. So we know also insolvency when the liabilities is more than the asset. No. So insolvent. Then the bankruptcy or insolvency of the supplier must be that as determined in the court of competent jurisdiction, because the insolvency cannot just be declared alone by the supplier or contractor consultant cannot say that, oh, we're already bankrupt based on our records. We're already bankrupt. We have more liabilities than assets. There must be a judicial decision. There must be a court decision that that particular entity is already insolvent, so that those remaining assets of the bidder will be divided in accordance with the rule or the law on which entity should be paid first out of that remaining assets of the bidder. So if there's finality of judgment, then finality of judgment of insolvency, then the procuring entity shall terminate the insolvent. Because how can the contractor perform its obligation when it's already insolvent? The termination will be without compensation, provided that such termination will not prejudice or affect any right or action or remedy which has accrued or will accrue thereafter. Okay. Termination for unlawful acts. The procuring entity may terminate the contract in case it is determined prima facie that the supplier or contractor or consultant has engaged before or during the implementation of the contract in unlawful deeds and behaviors relative to the contract acquisition and implementation. So pag makita ng procuring entity na may mga unlawful acts or behaviors ang ginagawa ng contractor, okay, then at that particular instance, that the procuring entity has the right to terminate the contract. Okay. So the termination for unlawful acts includes but not limited to the following. So these are the unlawful acts. Okay. Control, corrupt, fraudulent, collusive, and coercive practices. Diba? We have discussed that already before. in our penal provision of the 9184, because there's corrupt, fraudulent, collusive, and coercive practices. No, so controlling shareholders in common with another bidder. Actually, if you have to look at the same grounds, the termination for unlawful acts, no, the grounds are the same with that of the administrative liabilities, penal, and criminal. No, the same pa lang. Controlling interest in common with another bidder. Okay. So, nagbibid yung isa, pero may controlling interest siya, more than 20% of the shares, at least 20% sa kanya, yung isa pala, company pa rin, na nagbibid is, mayroon pa rin siyang 20%. Okay. Then, bidder receive any direct or indirect subsidy from another bidder. No? So nalaman na, pinafundingan pala ito ng itong bidder na ito, pinapandingan ng isang bidder of the same procuring entity. No? The same procuring entity, nagbibid silang dalawa, pero yung isang bidder, nagpa-fund, no? Nag-subsidize ng isang bidder who bidded also the bidder of the same procuring entity for the same project. Okay, bidders have the same legal representatives. Isa lang na tao ang kanilang authorized to represent the company. Okay. Bidder has a relationship with common third parties that may provide information or influence the bid of another bidder. Okay. Ito. Siyempre, yung confidentiality. No? Then, yung mga documents, FINORDs, no? Forged documents, yung mga nasa sinabit are forged documents. Okay. Termination by contractor or consultant. Okay. So, kung titingnan nyo, isa lang dito ang pwede, yung mismo ang procuring entity ang mag-determine yung termination by convenience, no? If it is economically or financially impossible to continue with the project, ano? Because of causes due but not limited to, no, changes in the law, rules and regulations. Okay. In termination by contractor, in contracts for infrastructure projects, the contractor may terminate his contract with a procuring entity if the works are completely stopped for a continuous period of at least 60 calendar days, though no fault of the contractor. Okay. It's beyond the control of the contractor. So, stop for continuous period of at least 60 calendar days. Failure of the procuring entity to deliver goods, supplies, okay, materials, or right-of-way, especially sa right-of-way. No? The contractor cannot complete the project, cannot complete the construction of roads because of right-of-way problem. Okay. Another items under the terms of the contract or work is disrupted by adverse peace and order situation certified by AFP Provincial Commander and approved by the Secretary of National Defense. No? So, siyempre, kung nag-gira na doon sa area, okay, more than 60 calendar days na, so pwede na ang contractor mag-terminate sa contract. No? It's more than 60 days. Pero kailangan continuous, no? Continuous na walang trabaho for at least 60 calendar days. So, kung interrupted yon on the third day may trabaho, hindi, that's not a ground for termination by the contractor or consultant. For consulting services, the consultant may terminate its agreement with a procuring entity if the latter is in material breach of its contractual obligation and has not remedied the same within 60 calendar days from receipt of the consultant's notice specifying such breach. So, ang breach dito, yung procuring entity. No? Siya yung nagbe-breach ng kontrata. So, then, the consultant can terminate the contract.
Okay, we are now on our second knowledge check. So again, all you have to do is choose the appropriate answers in the pop-up wall that shall be flashed into your screen. So the question is, the procuring entity cannot terminate the contract at any time for its convenience. Again, the procuring entity cannot terminate the contract at any time for its convenience. Is it A, true, or B, false? So if you're having or experiencing technical difficulties, especially on accessing our Zoom calling feature, please let us know through the Zoom chat box, and a member of our technical team will directly coordinate with you to address your concerns. Okay, so let's check. Currently, we have 50%, 50% for each options, the A and the B. May hahabol pa po ba? Okay, kung wala na, we will now be closing the poll in 5, 4, 3, 2, and 1. So, okay, let us share the result, please. So, for the second knowledge check, we have A true at 58% and B false at 42%. Attorney Vitor, tama po ba yung ang sagot ng nakararami? The 58%, which is A true?
Yes, it's true. The procuring entity can exercise or can terminate the contract by convenience. No? So I would like to reiterate that we hope the procure systems of conditions that make the project implementation economically, financially, or technically impractical and or necessary, such as, remember, but not limited to, fortuitous events, force majeure, or changes in law and national government policies. So the 58% got the correct answer. Thank you.
Thank you very much po, sir. So we'll now be resuming to our lecture topic.
So what are the procedures for the termination of contract? Okay. Of course, as part of due process, as part of the due process, it must be verified. No? Then notice to terminate. There must be a ground, no? Verified ground to terminate. Then notify the contractor. Then the show cause why it should not terminate the contract. Okay. The rescission of notice of termination, rescission in a sense that if the procuring entity has a ground that there's no need to terminate the contract, then in that particular instance, the procuring entity can resign the notice of termination of contract. Then it should be decided that the contract will be terminated, or if it is shown that it must be terminated. So the verification, okay, the first procedure for the verification of termination of contracts, in the verification, the implementing unit shall, or the procuring entity, within 7 calendar days from the receipt of written reports of acts or costs, which may constitute grounds for termination, verify the existence of such grounds and shall execute a verified report with all the relevant evidence attached. No? So, di ba, may sinasabi na termination, yung mga grounds, there are 5 grounds for termination. So, dapat may mga report na ganyan, na ganito ang na-commit ng isang contractor in order to terminate the project, the contract. So in that particular instance, the implementing unit of the procuring entity shall execute a verified report if the report or the acts which violates the contract are existing. Okay. So notice to terminate. So hopes shall terminate the contract only by written notice to the contractor, stating therein the following. Okay. Because of that verified report, the grounds and statement of the acts that constitute the grounds for which the contract is being terminated, the extent of termination, an instruction to the supplier, contractor, consultant to show cause why the contract should not be terminated. So that is a show cause order. With the other special instruction from the procuring entity, if any. So naka-attach na doon, nakasaad na doon yung grounds, no, as stated in the verified report. No, stated in notice to terminate. So the procuring entity may issue a notice to terminate or withdraw, resign the notice to terminate at any time before the receipt of suppliers, contractors, consultants position paper. Because di ba may show cause order. Of course, the contractor would give its answer to the show cause order. But prior to the receipt of the supplier or bidder's position paper, the procuring entity has the right to withdraw the notice to terminate. Withdrawal of notice to terminate shall be based on procuring entity's determination that items or work subject of notice has been completed, delivered, or performed. So sa tingin ng procuring entity, nagkamali pala ang procuring entity dahil kompleto pala, na-delivered na, at saka na-perform na ang trabaho ng isang contractor. So there's no need to issue a notice to terminate. So there's no need to terminate the contract. So sa show cause, di ba may show cause doon why it should not be terminated. So from the receipt of the notice of the termination, so within several calendar days, the bidder or the supplier, the contractor, consultant shall submit a verified position paper. Okay. So we know already what is verification, no? That it should be that this document, that this position paper is prepared by me, that I am the respondent of the particular case, something like that. That I caused the preparation the same, that based on authentic documents and or personal knowledge. Okay. Failure by the supplier contractor to submit the verified position paper within the reglementary period shall cause the hope to issue the order of termination. Okay. So kailangan within 7 calendar days mag-submit ng verified position paper. Failure to do so, then the hope will issue now the order of termination. So not after notice of termination, it's now the order of termination. Then the decision. Within a non-extendable period of 10 calendar days upon receipt of the verified position paper, the hope shall decide whether or not to terminate the contract. So remember, non-extendable period of 10 calendar days. From receipt of the verified position paper, the hope shall decide whether or not to terminate the contract. Okay. Failure by the supplier, contractor, consultant to submit the verified position paper within the reglementary period shall cause the hope to issue. No? Ito yung repeat na, no, di ba? Okay. So the termination shall be based only on the grounds stated in the notice to proceed. Of course, as part of due process. Kung yung ground to terminate is wala na mention in the notice to terminate, then that is a violation of due process law. The right of the respondent to due process to know the accusation against him or her. So kung nakita, that would be a violation of due process if the contractor or the bidder, the contract is terminated on the ground not based on the notice to terminate. Because the notice to terminate, di ba, may grounds din doon why the contract should be terminated. So yun po ang inatake ng contractor in his position paper. Kung ang termination in based not on the grounds stated in notice to proceed, then in that particular instance, the bidder was not able to defend himself. Okay, because the grounds are not stated in the notice to proceed, notice to terminate. So the Hope may create a contract termination review committee to assist him in the discharge of his function, especially in the decision. All findings or decisions of the CTRC are subject to the approval of the Hope, of course, because it is the Hope that will the last say, okay, in the termination of contract. Okay. So ito, 'di ba? Sa alternative method of procurement, meron tayong takeover of contracts. So takeover of contracts in that part, especially under negotiated procurement. So if the procuring entity terminates a contract due to default or insolvency or for a cause, it may enter into negotiated procurement pursuant to Section 53C of 9184 and 53.3 of its IRR. So ang gagawin ng procuring entity, pupunta siya doon sa second, kung sa goods or infra, the second lowest calculated and responsive bidder, and to the for consultancy highest rated responsive bidder, yung second highest, no, for negotiation. No. Invite, if not invite at least 3, no. So to continue the project. Sana yung 53.3.1 at 53.3.3. Ito yung negotiated procurement, no? Takeover contracts. The contract may be negotiated starting with the second lowest calculated or highest rated bidder for the project and consideration at the bidder's original bid price. No? So yung original bid price ng okay, yun ang basis in the negotiation. Okay. If negotiation fails, then the negotiation shall be done with the third lowest, no? So kung wala sa second, yung next na. Kung wala talaga, naubos na yung all of the bidders in that particular project, no? Failure yung negotiation, then mag-shortlist yung procuring entity, at least 3 eligible contractors shall be invited to submit their bids. A negotiation shall be made starting with the lowest calculated in the case of goods and infra and highest rated bidder in the case of consultancy. Okay. So authority to negotiate contracts for projects under these exceptional cases shall be subject to prior approval of the Hope within the respective limits of approving authority. Dahil iba, may limit sila sa authority. Ito lang, hanggang dito lang na amount yung pwede mong ma-approve. Okay. Okay. So ito yung sa termination for convenience, no? Yung procuring entity mismo ang nag-determine. But this only applies to contract for goods, no? Goods shall be accepted or performed or are ready for delivery within calendar days after receipt of supplier's notice to terminate at the contract terms and prices. So ito, 'di ba, may failure to deliver within 60 calendar days, no? Okay. Nag-issue na ng notice to terminate. If within 30 days after receipt of notice to terminate, naka-deliver ang contractor yung sa goods 30 calendar days, then the procuring entity shall accept that items, no, those items. So goods not yet performed or ready for delivery, the procuring entity may elect to have any portion delivered or performed and paid at the contract terms and prices, and or to cancel the remaining and pay to the supplier an agreed amount for partially completed or performed goods for the material and parts previously procured by the supplier. Okay. So written notice must be served to the procuring entity at least 30 calendar days before its termination. So ito yung kung ang contractor mismo, ang consultant mag-terminate ng kontrata, no? Yeah, yung no work within for a period of continuous no work for a period of 60 days or may mga base and order problem. So it must serve to the P at least 30 calendar days before its intended termination. The contract is then terminated if it is not resumed in 30 calendar days after receipt of such notice by the procuring entity.
Okay, so we finally reached the last knowledge check question for this session. But before we flash it on our screen, if you have questions related to our first module session for today, please feel free to drop them down through our Zoom chat box. And for our Facebook and YouTube live viewers, you may drop them down in our comment section. So, okay, moving forward, may I ask our technical team to flash the knowledge check question. The question is, in this procedure for termination of contracts, a verified possession paper shall be submitted by the supplier, contractor, consultant to the HOPE within 7 calendar days from the receipt of the notice of termination. Is it A, verification, B, notice to terminate, C, show cause, D, rescission of the notice of termination, or letter E, decision? Again, in this procedure for termination of contracts, a verified possession paper shall be submitted by the supplier, contractor, consultant to the HOPE within 7 calendar days from receipt of the notice of termination. Is it A, verification, B, notice to terminate, C, show cause, D, rescission of the notice of termination, or letter E, decision? So cast in your answers to our Zoom chat box. So currently we have 30% who participated. So we highly encourage our Zoom participants to cast in their answers to our Zoom polling feature. Okay? So for the Facebook and YouTube live viewers, again, you may also participate by dropping your answers down to our comment section. So may hahabol pa po ba? So currently we have 60%. Okay? So we will be closing the Zoom poll in 5, 4, 3, 2, and 1. So let us show the result, please. Okay, so for the result, we have A, 50%, B, we have 17%, C, we have 17% also. For D, we don't have any there's no point or percentage, and letter E, 17%. So, Attorney Vitor, ano po ba ang tamang sagot?
The correct answer is letter C, show cause. So only 17% of the respondents got the right or the correct answer. So it's a show cause, the paper that should be submitted by the supplier. Because the show cause order, no, it's a show cause because it would show the position paper should give a reason why it should not be or the contract should not be terminated. So that's why when the notice to terminate, there is a saying that you have to submit a show cause, that's a show cause order, a show cause to to answer, no, why the contract shall not be terminated. So that is the show cause, the verified position paper. So only 17% got the correct answer under letter C.
Okay, thank you very much po, sir. So next time, bawi-bawi po tayo for the following questions, no? Sana tumaas-taas naman po dun sa ating second module session. Okay? So, I think this ends our discussion proper for today's first learning session. So if you still have questions related to our discussion, and for our Facebook and YouTube live viewers through the comment section. So all related questions received are noted and shall be discussed in our open forum. So at this juncture, before we proceed to our open forum on the first learning session, let us first watch a short audiovisual presentation on government procurement. We may also take a short bio break, grab your coffee or some snack, and we'll see you in a while. Okay, I hope everyone is back. Again, that was a short audio-visual presentation on government procurement. So for more quick guide on government procurement and other related short video presentations, you may visit our official website at www. To proceed with the are initially guided from our comment sections are filtered as our resource speaker shall only be answering questions related to our first learning session. So nevertheless, rest assured that all questions raised and received are documented, which shall form part of our frequently asked questions. So once again, let us have our resource speaker, Attorney Anthony P. Vitor.
Okay, good morning.
So okay, so for our first question, we have, kung walang mag-initiate ng action to send notice to the supplier, even the back for supplier's refusal or not receiving the notice of award without justifiable cause, what will happen to the supplier? Are they relieved from the blacklisting procedure?
Kung wala mag-initiate ng action to send notice to the supplier, even the back for supplier's refusal or not receiving the notice of award without justificables, what will happen to the supplier? Okay. Actually, wala mangyari dito. Nothing will happen because there must be an initiation first from with regards to blacklisting, from the back, from the what's this observer, no? So there must be an action in order to determine that they are liable, no? So kung ayaw mag-initiate ng action, wala mangyari, no? Wala mangyari. They cannot be blacklisted.
Okay. For our second question, we have, who is the appellate authority for the Pope's decision in the municipality?
Well, it is not in the law, but for me, there is none because in the municipality, the head of the procuring entity is always the mayor, and while uh, while the while the government over the municipality, but there is no even the 9184 does not mention that the municipality could appeal any complaint. The appellate authority is the governor. So there is no appellate authority for me. There is of the decision of the local executive of the mayor. So you can go to court immediately to question the decision or to annul the award of the contract, whatever, in the case of municipality. And even if it is a city mayor or the provincial governor, there is no appellate authority other than the mayor, the governor themselves.
Thank you very much po, sir. For our next question, we have, what if a contractor or supplier presented a falsified document, say a contract previously entered? According to the Omnibus Sworn Statement, all documents he is presenting are correct. However, there is also a stipulation for the procuring entity that they are free to check and confirm the legitimacy of their documents. What is the liability on the part of the procuring entity if the documents were found later are falsified?
Liability on the part of the procuring entity of the documents. Now, well, in this particular case, it's probably the outsider. Then they are filing the case against the procuring entity. Well, in this particular procure the back uh, administratively and criminally, but outside the law, outside the RA 9184. They may be liable under Anti-Graft and Corrupt Practices Act for giving due advantage to that particular entity, even if it is the documents are falsified. Because in this particular case, the procuring entity himself is liable. No? So the BAC and that even the Hope may be liable in this particular case. But outside the 9184, they may be liable under RA 3019. Because 9184, the liability of 9184 pertains only to acts committed, of course, by the public officer of the procuring entity and that of the contractor. So if the procuring entity found out, if the procuring entity itself found out that the documents are falsified, then they can blacklist, no? They can, aside from criminal, civil, and civil liability of the contractor or supplier, they can also issue blacklisting order against the contractor or supplier. So in this particular case, since the procuring entity itself remits its duty, then they may be liable under 3019 or Anti-Graft and Corrupt Practices Act.
So thank you very much again, sir. So do we still have questions?
I think there's
there's
one in the chat box.
Yes, sir.
Allowed ba ang isang nahalal na opisyal o kasapi ng pamilya ng opisyal na sumali sa mga government procurement kung saan siya nanunungkulan? Okay. So, well, sir, from Compostela, well, it depends. Kung dahil nasa omnibus sworn statement kasi, di ba? Nasa omnibus sworn statement na he is not related to the head, to the back member, or employed in that particular agency, no? So kung ang tanong is siya ba official, well, it depends. Kung official po siya ng LGU, well, he cannot participate, or even his family cannot participate in the bidding in which the LGU is the procuring entity or even the end user, no? Pero kung ibang kung example, official siya ng LGU pero ang binibid is something like bidding ng is another LGU na hindi po siya official o wala po siyang pamilya doon na member ng BAC or something like that, then he can participate. So andun yun sa omnibus sworn statement na na wala po siyang pamilya, hindi po siya empleyado, is not related to the Hope or the BAC, whatever, no? So kung prohibition under the, even with the sworn statement, no? So he has a liability also. May liability din siya.
Okay, thank you so much po, sir. So do we have other questions po? So let's check. So from our Facebook comment section po, paano mapapatunayan na meron connivance between the supplier and the government officials involved sa bidding?
Okay. Yan ang sinasabi ko kanina. It's difficult, no? Unless there are third party who will testify that there's a connivance between the supplier and the government official, or one of the BAC members will testify that the mayor is dictating them or forcing them to coerce them to have this particular person bidder to be awarded with that particular bid, ano? Ang ano lang dito kung paano mo patunayan, well, isa sa mga red flag is yun bang bidder na yan or supplier na diyan. Parang siya ba ang nagko-control ng lahat ng supplies doon sa LGU? That's the red flag. No? Isa lang ba or dalawang supplier lang ang LGU? Even if there are many suppliers within the area, sila lang ba dalawang palaging nagsusupply? So that's the red flag. No? But to prove connivance, kailangan natin na yung insider, one of the insider would divulge the engagement between the supplier and the government officials.
Okay, so thank you po.
So I
Yes,
said,
sir.
yung isa sa red flag, yung palaging ang supplier, palaging siya yung nananalo. No? So kung isa lang na supplier, dalawang supplier lang ang nagsusupply sa isang, it may either the BAC or the hope. So that's that's the duty, that's the responsibility sana ng mga observer. So aside from COA, we have observers from NGO and those private sector. So because they are allowed to make a report, they are allowed to make a written report to the hope that this particular, there's something fishy with this bidding. So they shall make a written report to the hope. If the hope will still award a contract despite knowledge of that, despite that information from the observer, then the hope himself or herself is also liable. So they cannot anymore use what we call the Arias Doctrine, diba? Parang good faith yung mayor or governor na nag-approve. No, he cannot use that if there's a report from the observer. So yung observer sana ang may role dito, no, to determine the cash sabutan between the supplier and the government official. So I think that's all.
Okay, for our next question. Thank you po, sir. All right. Also, I think that was our final question under the first learning session on penal, civil, and administrative provisions. So again, thank you very much po, sir. So at this juncture, we are down to the second and final learning session for today's program. So to discuss and share his expertise on protest mechanism and blacklisting guidelines, once again, let us have our resource speaker back, Attorney Anthony P. Vitor. The floor is now yours, sir.
So let's go now to protest mechanism and blacklisting guidelines. Okay, outline for topic, protest mechanism, requisites for filing a verified protest, valid protest, procedure and resolution of protest, then blacklisting guidelines, blacklisting procedure during procurement stage, blacklisting procedure during contract implementation stage, and online blacklisting portal. So let's go first to protest mechanism. So protest in a sense that one of the bidders, especially when the BAC make a decision during procurement stage, and the bidder complained, or especially the losing bidder or disqualified bidder complained that the BAC erred in disqualifying its bid, and their documents should be admitted to something like that. So it says that at any procurement stage may be questioned by filing a request for reconsideration, because request for reconsideration is mandatory. No? So how it should be done? So within 3 calendar days from receipt of the written notice or upon verbal notification, with regards to the result or the decision of the BAC, then the bidder, especially the losing bidder, shall file a request for reconsideration within 3 calendar days from receipt, either written or in verbal notification. So what will happen is they have to do that within 3 calendar days. Just remember, it's calendar days. It includes Saturdays and Sundays or holidays. But of course, based on the rule, existing rule, the rules of court, that if the last day for filing is holiday, then the next working day should be the last day. So if the third day happens on Saturday, then the and Monday it should be submitted on Monday, the last the first working day after the holidays, or no working day. Then so the BAC should decide the request for reconsideration within 7 calendar days. So that's why in the technical working group there should be a recommendation that there should also be legal team from the technical working group that they would drop the request for reconsideration for in case of protest. So some would say, sir, what's the difference between request for reconsideration or motion for reconsideration? Well, for me, it's the same. It's the same. You're asking for, because motion is a request also. So it's a request. So it's the same. So you want to reconsider, the BAC would reconsider the decision. So if the request for reconsideration is denied, then that's the time that we would file a protest before the head of the procuring entity. So in the case of the LGUs, it should be the mayor, the governor, or the punong barangay. So if request for reconsideration or motion for reconsideration is denied by the BAC, then the BAC, the bidder may file a protest in writing before the head of the procuring entity. May, because it is not mandatory. If the BAC, if the bidder is already satisfied with the decision of the BAC and is satisfied with the how the BAC ruled in their request for reconsideration, then they will not file a protest anymore. But if they still contested, then they file to a protest. So the protest for reconsideration is mandatory. It's mandatory. If there is no request for reconsideration, protest cannot be done. So, and the protest can only be done also if the request for reconsideration has been resolved. So requisites for filing a protest must be in writing through a verified position paper. Now, verification that I, the complainant of this case, that has caused the preparation of this protest, that all the documents are in came from original documents, that are from personal knowledge. And the payment of non-refundable protest fee to be paid in cash, and of course a certificate against forum shopping. Well, the certificate against forum shopping would say that the bidder is not filing the same action before other body or quasi or judicial or quasi-judicial body. So non-payment of non-refundable protest fee. So that's why there are bidders that would complain immediately to the mayor, Mayor, dapat ganito, ba't ganito, ang back problema to. It should not be tolerated. It should, and the mayor would say, okay, back, anong nga naman, anong na may reklamo diri. It should not be tolerated. Because the bidder should file a request for reconsideration before the BAC. So that the BAC, if it ruled the disqualification by mistake, they can correct. The BAC can correct the mistake. So that would give the BAC the opportunity to correct itself. And also to pay, and for the protestant to pay the protest fee. Before the hope would rule on the protest. Para, ano ba yung protest? Of course, for the honoraria of back members, di ba? Okay. Then it should be addressed to the hope or the mayor, the governor, because it is these people who will decide, no, the protest. And it should be filed within 7 calendar days from receipt of the back resolution denying the request for reconsideration. So, the position paper would state the bidder's name and office address, no? The name of the project or the contract, the implementing office or the procuring entity, brief statement of facts, issues to be resolved. No, of course, the issues to be resolved, why it is disqualified, something like that. Why the documents is denied. So other matters information pertinent and relevant to the proper resolution of the protest. So then the last is the certification against forum shopping. Okay. So ito yung verification. The defiant or the complainant has read and understood the contents thereof and allegations therein are true and correct of his or personal knowledge or based on authentic documents. No? So if there is no verification, it is considered a mere scrap of paper. So outright dismissal of the protest. Unsigned, produce no legal effect and results to outright dismissal of the protest. So failure to comply shall not be curable by amendment of the verified position paper. So, di ba, within 3 days, you should file a request for reconsideration. No. So, if there's something kulang, no, they cannot amend, meaning they cannot file another verified position paper with amendment. They have to file a new verified position paper. So, bayad na naman sila ulit. Okay, dahil kung amendment, walang bayad. So, a new verified position paper. Ang problema nito, kung they file the protest nang sa deadline na. Example, the third day, doon pa sila nag-file. Problema pala, kung may time pa, then they can do that. They can submit a new verified position paper. Kung wala ng time, they cannot file that anymore. No? So on the second day ba or morning ng third day, nakasubmit sila ng position paper ng protest, then pag tingin nila, uy, kulang, o may problema, or walang verification, or walang certificate of non-forum shopping, they can file a new verified position paper. But they cannot amend. Ang amendment kasi, nandun yung first nilang verified position paper, tapos may amendment. So parang carry over pa rin yun sa deadline ng first position paper. No. Pero kung sa ganito, walang carry over. Hindi yun na dahil nakasubmit ka sa first verified position paper on the last day, may amendment na, pwede pa yun dahil ang position paper nakasubmit on the third day, kung may amendment, mag-recon pa rin yun sa third day. Pero kung walang amendment, kung new verified position paper, hindi na siya pwede makasubmit dahil that is considered new. No? Okay. Resolution of protest. So reset of denied protest for reconsideration. Okay. Filing of protest within 7 calendar days from receipt of the party concerned of the resolution of the BAC denying its request for reconsideration. Okay. Kung granted kasi yung request for reconsideration, of course, yung ino-object nila, mag-carry na yon, mag-grant na yon. Kung sinasabi na deny sila because of that, then kasama na sila sa qualified bidder. Okay. And the hope shall resolve the protest within 7 calendar days from receipt. then the head of the BAC Secretariat shall furnish the bidder with a copy of the decision within 7 calendar days from receipt. No. So the filing of protest should be in the verified position paper with certificate of non-forum shopping and payment of non-refundable protest fee. Okay. Ini also to discourage naman protest. Okay. Any protest taken from any decision treated in 9184 and its IRR must not be stay or delay the bidding process. However, walang award unless ang protest ma-resolve. No. Unless ang protest ma-resolve, walang i-award. Court action may be resorted to only after the protest shall have been resolved with finality. Okay. So that is what we call the doctrine of exhaustion of administrative remedies. Kung walang protest, di ba? Mandatory yung request for reconsideration, then protest. Kung wala silang protest, then they cannot file an action for petition for annulment of the award before the regional trial court, because protest is condition sine qua non. Kumbaga, kung walang protest, then it should be denied. No? Yung petition for annulment of the award will be denied, so shall be denied because walang exhaustion of administrative remedies. Okay, ito yung protest fee, no? So, kung ang ABC is 50 million pesos and below, ang protest fee is 0.75%. Kung more than 50 million to 100 million, 500,000, more than 100 million pesos to 500 million, 0.5% of the ABC. More than 500 million pesos to 1 billion pesos, 2.5 million. More than 1 billion pesos to 2 billion pesos, 0.25 of the ABC. More than 2 billion pesos to 5 billion pesos, 5 million pesos ang protest fee. Kung more than 5 billion pesos, it is 0.1% of the ABC. So yun.
Okay, so we are now on our first knowledge check question for this session. So again, you know the drill. All you have to do is choose the appropriate answers in the pop-up poll that shall be flashed in our screens. So the question is, the non-payment of the protest fee does not toll the prospective period for filing a protest, and it becomes a justifiable basis for the hope not to entertain a protest. Again, the non-payment of the protest fee does not toll the prospective period for filing a protest, and it becomes a justifiable basis for the hope not to entertain a protest. Is it A, true, or is it B, false? So key in your answers through our Zoom polling feature. So again po, for our Facebook and YouTube live viewers, you may also participate by dropping down answers through our comment section. So right now we have 61%, okay, 73% for true and 27% for false. So habol po tayo. Okay? So we are closing our poll in 5, 4, 3, 2, and 1. Okay? So let us request our technical team to share the result. So for our first knowledge check for this session, we have the result A for 73%, and for B, we have 27%. Sir, tama po ba ang majority?
Yes, tama po sila. 73% of the respondents got the correct answer. So non-payment, so when the protestants would like to file a protest, so simultaneously they have to pay the protest fee. If they will not pay the protest fee, so it is the protest is considered a mere scrap of paper, and the hope is mandated not to entertain the protest. So dapat magbayad sila.
Okay po, thank you very much, sir. So we'll now resume on to our lecture proper.
Okay. Let's go now to uniform guidelines on blacklisting. Okay. So the guidelines on blacklisting is based on GPPB Resolution number 40-2017, approving the revised uniform guidelines for blacklisting of manufacturers, suppliers, distributors, contractors, and consultants. It was approved on December 21, 2017, but effective only on September 4 of 2018. Okay. Then, another GPPB Resolution number 14-2020, approving the prescribed form of blacklisting order, the implementation of the online blacklisting portal for posting and updating of status of blacklisted entities. It was approved on June 25, 2020 and effective on August 7, 2020. Okay. So blacklisting is part of administrative penalty disqualifying a person or an entity from participating in any government procurement for a given period. Okay. So blacklisted person or entity, a person or entity who was disqualified by an agency or included in the GPPB Consolidated Blacklisting Report. So, but before a certain entity or person is blacklisted, there is prior suspension. So it's an interim penalty. Okay. Suspension is the interim penalty imposed for infractions committed by a bidder during the procurement stage, whereby such bidder is prohibited from further participating in any of the bidding process of the agency. Shall be effective during the period of motion for reconsideration and or appeal and shall terminate only upon decision by the hope or appellate authority. So ang suspension happen, for example, Municipality X, may bidding, sinuspend niya yung isang bidder because of infraction. Yung company, example, bidder A, so the bidder A cannot participate in any further bidding in that municipality. But that bidder can still participate in the bidding of other agencies, no? Of other LGUs. Pwede pa. No? No. Pero kung blacklisting na, wala na pong pwedeng mabidingan po niya. Dahil lahat ng government agencies, blacklisted po siya. Kahit isang municipality lang ang nag-blacklist, blacklisted yung isang bidder sa lahat ng government agencies. Sa suspension, dun lang sa nag-suspend na hindi siya pwedeng makaparticipate sa bidding. Okay. Who are the appellate authorities? Well, sa LGUs, sino bang appellate authority? There's no more appellate authority for the LGUs because mayor na lang. Mayor. Okay. Pag ano na sa mayor, then they have to file an action. No. Blacklisting decision of government agencies that are not subject to general or administrative supervision or control of any department or office, the government unit shall be final and executory. Okay. So doon sa consolidated blacklisting report, nakasad naman doon kung how many years, 1 year or 2 years pang blacklisting. Pag na-meet na yung year, then automatic delisted as blacklisted ang person or entity. Okay. So apply sila the blacklisting sila apply to the following persons. Individuals or sole proprietorship, bidders and spouses. Okay. Kung yung mga single proprietor or individual na bidder, Si Mr. A, meron siyang business, no? Si spouse, husband. Yung wife naman, meron din, separate, no? So kung si spouse, husband, blacklisted din yung spouse, wife na entity. So yung mga partnership, kung ang isang partner blacklisted, okay, kasama na yung partner po niya, no? Blacklisted din. So kung yung partner niya may iba ding negosyo na pwede makabid sa government, then blacklisted din yun. For cooperative, no, the cooperative itself and the members of the board of directors, general manager, or executive officer. For partnership or joint venture consortium, or has a blacklisted member and or partners, as well as a person or entity who is a member of blacklisted joint venture or consortium. So yung mga kasama doon sa partnership, joint venture, consortium, kung may mga negosyo din sila, blacklisted din. Then kung corporations, a single stockholder together with his or her relatives up to the third civil degree of consanguinity or affinity under an assignee holding at least 20% of the shares therein. No? So kung isang corporation, isang bidder, binacklist po ninyo, then 20, kung ang isang stockholder doon, yung may isa ding corporation nagbibid, no? Nagbibid po sa inyo. Pero that bidder owns, one of the stockholder owns 20% of the blacklisted corporation, then that corporation na nagbibid na di pa na blacklist, kasama yun sa blacklisted. Dahil isa sa owner doon may control sa at least 25% sa blacklisted corporation.
Okay, ang bilis. So we are now down to our second knowledge check question. Alam nyo na po ito. So all you have to do is choose the appropriate answers in the pop-up poll that shall be flashed in our screens. So the question is, blacklisting is an interim penalty imposed for infractions committed by a contractor during competitive bidding stage, whereby such contractor is prohibited from further participation in the bidding process of an agency. Again, blacklisting is an interim penalty imposed for infractions committed by a contractor during competitive bidding stage, whereby such contractor is prohibited from further participation in the bidding process of an agency. Is it A, true, B, false? Okay, cast in your answers through our Zoom polling feature. So if you still have questions in mind, please let us know through our Zoom chat box. And for our Facebook and YouTube live viewers, you may use our comment section. So all related questions shall be discussed and answered by our resource speaker during our open forum. So upon checking, 72% casted their answers already. So we will be closing the poll in 5, 4, 3, 2, and 1. So let us share the result, please. So for the second knowledge check for this session, we have A, true for 69%, and we have B, false for 31%. Attorney Vitor, ano po ba ang tamang sagot?
So the answer is true. No? The interim penalty is suspension, not blacklisting. So prior to blacklisting, the entity still on suspension. Therefore, it cannot participate in the bidding of that agency which suspended the bidder. After that, if the decision, if that suspension becomes final, and executory, and that's the time that a blacklisting order be issued. So the interim penalty is suspension. So the answer is true.
Thank you so much po, sir. Congratulations po to the majority who answered true. So let us now resume our lecture proper.
So there are two stages in blacklisting: during procurement stage and during implementation stage. So let's go first with the during procurement stage. Okay. Actually, pare-pareho lang, more like the same with the liabilities, no, sa administrative, penalty, civil, and criminal. More or less the same ground, no? So, di ba? Containing false information or falsified documents, submission of bids that contains false information or falsified documents, or concealment of such information in bids in order to influence the outcome of eligibility screening and or any other stages of the public bidding. Then refusal to clarify or validate in writing its bids during the post-qualification with a period of 7 calendar days from receipt of request for clarification. Okay. Any documented, unsolicited attempt by a bidder to unduly influence the outcome of the bidding in his favor. Okay. Allowing the use of one's name or using the name of another for purpose of public bidding. Okay. Withdrawal of a bid or refusal to accept an award or enter into contract without justifiable cause after it has been adjudged as having submitted the lowest calculated unresponsive bidder or highest rated responsive bidder in case of consultancy. Okay. Refusal or failure to post the required performance security within the prescribed period. Okay. All other acts that tend to defeat the purpose of the competitive bidding, such as habitually withdrawing from bidding or submitting late bids or patently insufficient bids for at least 3 times within a year, of course, without valid reasons. Okay. So these are the grounds for blacklisting during procurement stage. As I said, this is the same ground, or most of these grounds are the same grounds in penal committed, in which the private or public officer is criminally, civilly, and administratively liable. So what are the sanctions for blacklisting during procurement stage? Of course, the bid security. Diba? Nag-deposit sila ng bid security, ma-forfeit yung bid security nila. Then, first offense, blacklisting for 1 year. Second offense, blacklisting for 2 years. Or enforcement of bid securing declaration, di ba? Kung wala kang allow yung walang bid security, then yung enforce yung bid securing declaration. So, ang ano doon is blacklisted pa rin. No? So, without prejudice to the imposition of additional administrative sanctions, as the internal rules of the agency may provide and or criminal prosecution. So, we have discussed that before. Okay. Ito, during procurement stage. So, who will initiate? Any bidder or prospective bidder, any authorized observer, or the BAC itself can file a blacklisting action. No? So, contractors shall refer to manufacturers, suppliers, distributors, contractors, and consultants. So the BAC notifies contractor in writing upon verification of existing grounds that a complaint has been filed, that is opportunity to show cause, the hearing, no? So may show cause order yan. These are the grounds for you will be show cause why you cannot be blacklisted because you committed the following grounds to offenses. So that the complaint has been filed, no? Ito yung kasama yung sa show cause order that has the opportunity to show cause that a hearing shall be conducted upon request, the consequences of being suspended and blacklisted. Because yung request for hearing, discretion yun sa respondent kung gusto pa niya magpa-hearing. Kung ayaw niya, okay lang. No? The consequence of being suspended and blacklisted. So the contractor shall submit its written answer to BAC with documentary evidence and request for hearing, if so desires, within 5 calendar days from receipt of notification. So remember, it's 5 calendar days. No extension is allowed. Of course, dahil kasi, di ba, if allowed ang extension, madidelay yung bidding. Okay. If contractor does not submit an answer, because the contractor, after receiving the show cause order, pwede naman din di siya mag-submit ng answer. Okay. So, with that, the BAC will, dahil walang answer, recommend to the HOPE the suspension of the contractor and the forfeiture of bid security. So, within 15 calendar days from receipt of the BAC resolution records of the BAC proceeding, the HOPE determines whether there is a reasonable cause to blacklist the contractor. So, it's either to dismiss the case. Kung may reasonable cause, issue ng suspension, then forfeiture of bid security. Okay. So, suspension order and bid. Wala pang blacklisting dahil sa dapat yung suspension order becomes final and executory. That's the time that ma-issue na po yung blacklisting order. So kung mag-submit po siya and requested for hearing, so yun, request for hearing, yes, ang BAC magkakandak ng hearing. Kung hindi po siya nag-request for hearing, the BAC will determine the existence of fault based on the complaint, answer, and documentary evidence and facts verified. So kung walang hearing, doon yung BAC will just base their decision on the papers submitted to them, the complaint and the answer. No, yun lang. Kung ng hearing, the BAC will set the date and time for hearing. Then, of course, will decide the case based on complaint, answer, and the documentary evidence and facts verified. Okay. Then, submit to the HOPE. No? So again, the HOPE would dismiss or issue suspension order and forfeiture of bid security. Okay. Okay. So the HOPE shall furnish the suspended contractor a copy of the decision after its promulgation. So what's the effect? So suspended immediately upon receipt of the notice of the decision. Okay. The bidder, the suspended bidder, has the right to file a motion for reconsideration, and if denied, can appeal. No? And shall terminate only upon the reversal of the decision by the HOPE or appellate authority. So, if the motion for reconsideration or appeal is filed, the decision shall become final and executory after the lapse of 7 calendar days. And that's the time na nag-issue na po ang HOPE ng blacklisting order. Okay. Because the motion for reconsideration or appeal is a privilege. No? It's not a right, meaning it's up for the suspended bidder to file a motion for consideration or appeal. He cannot be forced to do so. It's up for him. It's up for the bidder. So kung wala siyang motion for consideration or appeal to the decision of the HOPE, suspending or blacklisting the bidder, mag-issue, suspend, then i-blacklist na po siya after 7 calendar days. Okay. So, file siya ng motion for reconsideration. HOPE resolves the motion. So, file siya ng motion for reconsideration. That the decision, within calendar days from receipt of the decision the basis of the motion for reconsideration is that the decision does not conform with the evidence or facts, or there is a newly discovered evidence. Okay. Then, or nagpa-file siya ng appeal, no? Kung walang appeal, within 7 calendar days, after 7 calendar days, ang hope mag-issue ng blacklisting order. Yung kung nag-file siya ng appeal, then the appellate authority shall resolve the appeal within 7 calendar days. So if appeal is not granted, hope issued blacklisting order. Okay. Filed with the appellate authority within 7 calendar days, yung appeal. So ang MR dapat 3 calendar days. Ang appeal is 7 calendar days. So ito, during contract implementation. Okay. So what are the grounds for blacklisting during contract implementation stage? Okay. Failure of the contractor due solely to his fault or negligence to mobilize and start work or performance within the specified period in the notice to proceed. Okay. Failure by the contractor to fully and faithfully comply with its contractual obligations without valid cause, or failure by the contractor to comply with the written lawful instruction of the procuring entity or its representative pursuant to the implementation of the contract. Ito, assignment and subcontracting of the contract or any part thereof or substitution of key personnel named in the proposal without prior written approval by the procuring entity. So assignment and subcontracting is bawal. No? Dahil kung may subcontractor po, dapat kasama yon sa kung i-allow yan ng procuring entity, dapat kasama yon sa bidding. Dahil the qualification of the contractor should be the same with the main contractor. Okay. Yung ginagawa natin ng mga subcontracting, actually, hindi yun natatawag natin. We can't call that subcontracting because, well, between the main contractor and that the subcontractor, it's subcontracting. But for the procuring entity, there is no subcontracting. So the liable is always the principal contractor. So kung nagkamali yung subcontractor, yung principal contractor pa rin ang liable. No? Dahil walang approval. No? Bawal yun. Ito yung substitution of key personnel named in the proposal, especially kung especially sa consultancy, di ba? Sa consultancy, the government will hire consultants based on expertise, based on experience or educational qualification. During the bidding, nakasad na 15 years experience in this particular field or has a doctorate degree, iyong pinalit na personnel a master's degree holder or not a doctor's degree holder or 10 years ang experience. No, ang kailangan natin ang original is 15, yung nagpumalit 10. So that is not allowed without written approval. Ito, for procurement of goods, no? Unsatisfactory progress in the delivery of the goods by the manufacturer, supplier, distributor arising from his fault or negligence or inferior quality. No? Inferior, hindi nakakomply sa specification ng during sa bidding. May mga specs, so yun ang minimum dapat na i-meet ng bidder. So kung yung specifications, no, inferior yun sa, yung nabigay na mga goods is inferior to the or unsatisfactory to the specification specified in the bidding, then that would be the bidder is liable for or maybe blacklisted. Okay, consulting for services for performance by the consultant or services arising from his fault or negligence. Okay. For the procurement of infrastructure projects, poor performance by the contractor or unsatisfactory quality and or progress of work arising from his fault or negligence as is reflected in the CPIS or the existing performance monitoring system of the procuring entity. Okay. So, willful or deliberate. So, kailangan willful or deliberate yung pag-abandon. Kung may grounds, no, may justifiable cause. Well, ito yon. Without justifiable or lawful cause. Abandonment or non-performance of the project or contract by the contractor resulting to substantial breach thereof without lawful or just cause. May gira doon. Dahil sa bagyo, naging inaccessible yung area. So that would be a ground. That would be a justifiable cause. So in case it is determined prima facie that the contractor who has engaged before or during the implementation of the contract in unlawful deeds and behaviors related to the contract acquisition and implementation as enumerated, pwede yan sa ground for the termination of the contract. Sanctions. Okay. Dahil during contract implementation, di ba, may award na, dapat ang ma-forfeit yung performance security. Forfeited yan. The same, blacklisted for 4 years for the first 1 year for the first offense, blacklisted for 2 years for the second and subsequent offenses. Again, without prejudice to imposition of additional administrative sanctions as the internal rules of the agency may provide, and or further criminal prosecution. Okay. So, blacklisting procedure during contract implementation. So, upon termination of contract due to default or unlawful acts of the contractor, the HOPE shall issue within 7 calendar days a blacklisting order. Okay. Where notice contract termination is no longer possible, okay, but the contractor committed acts or causes which may constitute grounds for blacklisting, the implementing unit shall, within 7 calendar days after the lapse of project duration, cause the execution of verified report with all the relevant evidence subject to the following procedure. Of course, notice, show cause, decision, notice to the blacklisting, no? Notice of blacklisting. Okay. So, tapos na po yung project. No? Based on the time, no? So, nilapse na po yung duration. So, dapat within 7 calendar days, no? Dapat within 7 calendar days, dapat may verified report, no? That to be attached for the notice of blacklisting. Remember, 7 calendar days after the lapse of project duration. After 7 days, you have no more ground because under the law, pag yung 7 calendar days, that is mandatory. Okay. So yun. Okay. So the HOPE shall initiate the blacklisting procedure by written notice to the contractor. Okay. That is, of course, due process. Due process pa rin. Let the contractor contradict the allegations of the procuring entity. So a statement of the acts that constitutes the grounds for blacklisting. So ano yung grounds, di ba? We have already mentioned about grounds for blacklisting during contract implementation. So yun. Instruction to the contractor to show cause as to why it should not be blacklisted, and instruction and special instruction to the procuring entity if any. No. So the notice of blacklisting shall be accompanied by a copy of verified report. Verified meaning may verification pa rin, di ba? Just like the protest. So within 7 calendar days from receipt of notice of blacklisting, the contractor shall submit to the HOPE a verified position paper stating why it should not be blacklisted. That's just show cause. No? If the contractor fails to show cause after the lapse of 7 calendar days, either by action or by default, the HOPE shall issue a blacklisting order. So the second paragraph, kung after 7 calendar days, no, walang sinabit na action or show cause ang contractor, ang HOPE can issue immediately the blacklisting order. Okay. So the decision is based on the paragraph 1, the first ballot, when the contractor submitted a verified position paper. No. So if the contractor submitted a verified position paper within 7 calendar days, then the hope shall within non-extendable period of 10 calendar days from receipt of the verified position paper, the hope shall decide whether or not to blacklist the contractor. It shall serve a written notice to the contractor of its decision, which shall become final executory after the lapse of 7 calendar days from the receipt of notice of the decision. Okay. So, kailan maging final executory? Of course, kung walang MR, walang appeal. So, example, if the bidder did not file a motion for consideration and decision to suspend, diba, suspension ng muna, decision becomes final executory after the lapse of 7 calendar days counted from the receipt of the notice of decision. Okay. Walang MR. Second, if the bidder did not file an appeal, no? May MR po siya, may motion for reconsideration, pero deny yung motion for reconsideration, dapat mag-appeal, pero hindi siya nag-appeal. Then, that decision becomes final executory after the lapse of 7 calendar days counted from the receipt of the resolution on the denial of their motion for reconsideration. Third, if an appeal was filed and the same was denied, the decision becomes final executory upon receipt of the agency and or person entity concerned on the decision of protest. Okay. Status of blacklisted person. Before issuance of blacklisting order, suspended pa lang. So the airing contractor may participate in the procurement of any government project except in the agency where is suspended. So this is suspension. Okay, blacklisting order issued before the notice of award. Of course, kung may shall not be, kung before the issuance of notice of award, then it shall not be awarded to the qualified bidder, but to the second, doon ka na sa second responsive, lowest calculated responsive bidder. Second, third, kung consultancy, the highest, second highest, something like that. Blacklisting order issued after the issuance of the notice of award. Okay. The award of or awarded project or contract shall not be prejudiced by the said order, provided that the said offense are connected with the awarded project or the contract. Okay. So kung ibang project yan, no, may notice of award na, that's the time after na issue, then after the issuance of notice of award, na issue yung blacklisting order. So yung awarded project, it cannot be affected, no, unless not connected, and hindi yan affected, no. Affected yan if connected with awarded project. Okay. This one is after the issuance of notice of award, but before the issuance of blacklisting order. So, continue pa rin yung project niya po na may notice of award na po. Pero kung doon sa agency concern, even after the notice of award at saka yung yung may notice of award, the same project yon sa kanyang na-issue na blacklisting order, hindi na pwede yun. Okay. Even if may notice of award. So the effectivity period for the penalty shall be clearly stated in the blacklisting order and shall commence in the same date as of each issuance. Okay. Penalty. Remaining period, di ba sabi natin, first offense, 1 year blacklisting. Second and subsequent offense, 2 years. Second offense, 2 years. Third offense, 2 years. Fourth offense, 2 years. So, period of previous, so plus 2 years. Plus 2 years. Kung offenses na po, marami, third offense, second offense. So, ano yung remaining period niya, then plus 2 years. Okay. Example, nakaserve siya ng 1 year and a half. Second offense na po niya. So example, sa first offense, serve siya ng 1 year. Pero half year pa lang, may another blacklisting order. That's a second offense. So plus yung new 2-year blacklisting order start from 6 months, no? Hindi na pwede tapusin yung 1 year, 6 months plus 2, no? This is for the first offense, remaining period plus 2 years. Yung second, yung remaining period example, 2 years. 2 years and a half na po. So 2 years and a half plus 2. Okay. If subsequent offenses. Okay. So ito yun, no? The GPPB makes it easier for us, no, to issue blacklisting order. Ito lang, checklist lang. Ito lang naka-check lang anong violation. Ito na. Okay. Okay. It is a downloadable form. No, nakasad na doon ng project, anong agency, no, nakasad na doon. So it's not it's easier for the hope or the appellate authority to issue the hope to issue blacklisting order. Okay. Ito yun, nakasad nun. And actually, it's already here in the form. It's already here. Sa online blacklisting portal, punta ka lang sa sa GPPB na website, then nandun yung online blacklisting portal, no. So, electronic facility developed by GPPB TSO para ang mga procuring entity makapost doon ng blacklisting orders. So, doon yun ng mga blacklisted bidders. So, the blacklisting orders must be posted in the portal 3 calendar days from the date of its effectivity. Okay. In case of unlawful order from a judicial or in case of a lawful order, example, may mga restraining order or may yung mga appellate or court directing the temporary or permanently lift the period of suspension or remove the name of blacklisted entity from the consolidated blacklisting report, the PA through its official alternate user shall immediately remove the name of blacklisted entity upon receipt of the order. So dahil yung sa portal, dapat may isang official lang employee lang talaga na pwede maka-login doon. At saka isang alternate user. Just in case wala yung main, no? So the blacklisting entity shall only be qualified to participate in all government procurement during a period of the temporary lifting or removal. No. Example, kung temporary, TRO, 20 days for the regional trial court, so 20 days. After 20 days, balik na rin pa yung blacklisting kung walang permanent restraining order. Okay. So dapat ma-adjust para lang ma-serve niyo yung 2 years or 1 year penalty.
Okay, so we finally reached the last and most awaited knowledge check question for today. So we will be having our price knowledge check question. So may we ask our participants to type in their answers to the Zoom chat box. And again, the GPP BTSO will give another special token to the first participant who will answer the question correctly. So, but please take note that only participants following the required name format, which is your municipality name underscore your full name, shall be qualified, and those who were given special tokens already will not be considered to give way to other participants. So the question is, when does blacklisting order become final and executory? Again, when does blacklisting order become final and executory? Is it A, if the bidder did not file a motion for reconsideration on the decision to suspend, said decision becomes final and executory after the lapse of 7 days counted from receipt of the notice of the decision? Is it B, if the bidder did not file a protest after his motion for reconsideration has been denied, the decision becomes final and executory after the lapse of 7 days counted from receipt of the resolution on the motion for reconsideration? Is it letter C, if a protest was filed and the same was denied, the decision becomes final and executory upon receipt by the agency and person or entity concerned of the decision on the protest? Or letter D, all of the above? Again, when does blacklisting order becomes final and executory? So let's check our Zoom chat box. From our Zoom chat box, we have from LGU Manolo for Teach, Sir Graham, letter D. LGU Quezon Bukidnon, Ma'am Betel, letter D. LGU Kabugao, Ma'am Jovi, letter B. Okay, mostly po ang answer ay letter D. Attorney Vitor, ano po ba yung tamang sagot?
Well, the majority got the correct answer. The answer is all of the above. No? So if this particular these three things would happen, then the decision becomes final executory, and the procuring entity will now issue a blacklisting order. So all of them got the correct answer.
Okay, congratulations po, no, sa lahat ng nakakuha ng tamang sagot. May it be from our Zoom participants or YouTube and Facebook Live viewers. Meaning lang po, sir, talaga pong nakikinig talaga sila sa ating session. Ano po? Kasi they get the correct answer po, even though medyo maraming choices, but at the end of the day, they had the correct answer. Okay? So our knowledge check winner for today, upon verification and validation of our technical team, we would like to congratulate Ma'am Bethel Jane Monzelin from the Municipality of Quezon, Bukidnon. So, Ma'am, congratulations po. And to our winners for this week, special tokens, please check your messages as our event secretariat contacted you on how you may claim your prizes. So again, thank you so much po to our participants for actively participating on our polling questions. I think also that ends our discussion proper. Tama po ba? Can I see the last slide, please?
That's all for
yes, sir.
Our topic, and good day to all of us. So probably some of you have questions, then we can have an open forum.
So ayan po, no? That ends our discussion proper. Thank you very much, sir. Again, that was our GPPB recognized trainer, Judge Anthony P. Vitor, presiding judge at the Municipal Trial Court of Jabonga, Kicharo, Agusan del Norte, and an instructor of College of Law of Father Saturnino Urios University, Butuan City. So to proceed with our second and final open forum, once again, we have our resource speaker. So
Okay,
let us have, yes sir.
the open forum. Let's have open forum na.
Yes sir, ako.
Okay.
So we now proceed with our first question. Ayan, sir. So for our first question on the second learning session, would there be a negative effect to the agency if it blacklists suppliers?
No, there's no negative effect. It means that the agency is implementing the law, and the agency is you know the act of the agency is always favorable, to the government, because they immediately acted on the illegitimate or unlawful acts of the supplier. So blacklisted kagad. So walang negative effect 'yun sa agency. So kung sino mang magbibid sa that in that particular agency, then they have to see to it that they are they participate, or they will participate in the bidding process in accordance with the law, rules and regulations.
So ayan po, no? Thank you very much, sir. So we will be having the second question. For the second question, in the event na nag-file ang bidder ng request for reconsideration to the BAC, then the BAC take action or resolution beyond the prescribed period of 7 calendar days, may administratively or criminally liable ba si BAC?
Okay. Yes, because under the law, and even the jurisprudence by provided in the law, and even the decision pertaining to 1981-84, that the days prescribed in the law is mandatory. So they have to decide that within 7 calendar days. Now, if they failed to decide within that period, then the other party, the bidder, can already argue that any decision, or if the PAC will decide the case beyond the 7 calendar days, then that decision is already or the complainant itself could say that the decision is null and void, and the back maybe administratively or criminally liable in this particular case. Maybe administrative failure to decide within the period. So that's why it's not easy to be a back member or a back member. No, it's not easy. It's but it's a jury duty. No? So, but it's not easy. No? Considering 7 calendar days, and for the LGUs, that's not only our responsibility. We have also our regular duties aside from being a back member. So, but we have to follow the law. We have to decide within the prescribed period. Thank you.
Ayan, thank you very much po, sir. So on to the next question po. If a procurement is being divided artificially into small lots of procurement, but still use public bidding as mode of procurement, could it be considered as splitting of contracts?
Okay, but still now, well, as a general rule, the splitting of contract is a violation if, especially, the purpose is to avoid following the procurement law, especially the public bidding. Okay, now if it is divided into smaller lots artificially, I don't know why it is artificially, but still public bidding. It's only my opinion. There is no violation of the splitting of contract. There's no violation if they do procurement using competitive bidding. It's not There's no violation of splitting, because again, splitting is used to avoid competitive bidding. So for me, it is not an splitting. It's not splitting.
Okay po. So going on to our next question. Is there a liability on the part of the procuring entity if they did not impose liquidated damages or blacklisting to an erring contractor? Sample, the project was not completed as per project duration period without any valid reason, and they did not request for any contract extension.
Okay, of course, there's a violation to impose. No, I've known a mayor, a certain mayor, cases filed against him for failure to impose liquidated damages of 1/10 of 1% for every day. The ability of the Hope, no, it's now the duty of the Hope to impose liquidated damages, and if not, then the Hope is liable for that. No, as I said, I know one mayor case was filed against him for refusal or failure to impose liquidated damages. Even blacklisting. No, well, with regards to blacklisting, uh, kung hindi sila nag-blacklist, no, then walang mangyayari, no. It cannot be taken against the Hope or against the procuring entity, or it cannot be taken against the bidder if nobody will file a verifications, because there must be a complaint, no. Kung walang complaint pertaining to blacklisting, so pwede pa rin yung ano yon, yung bidder can participate in other procurement in other government agencies dahil walang blacklisting order. But in liquidated damages, klaro kasi yun eh. Every delay, you have to impose 1/10 of 1%. So, may liability ang procuring entity if it will not impose liquidated damages.
That was very informative po, sir. Thank you very much. On to our next question. We have, may a bidder raise as an issue the alleged incapability of the municipal engineer in preparing the detailed plan so that the costings are considered erroneous. Thus, the bidder may be allowed to refund the cost of the bid docs that he paid.
Now, okay. Well, in this particular case, uh, if the bidder sees that the municipal engineer is erroneously make a costing, that particular costing of the particular project, he has no opportunity or even the right to raise that, because at the first place, if he thinks that the municipal engineer erroneously prepared the detailed engineering plan, then she should not participate in the bidding in the first place. Because if he will participate in the bidding, he knows that it's a losing part for the bidder. So there's no way that he will file for a refund. No, he should. If he would not participate, it's the bidder's duty or right not to participate if the detailed engineering plan is wrong. Because if that would, even if other bidders would knows that still that's also wrong, then they will not participate. So there will be a failure of bidding. So they are not, the bidder may not be allowed, they're not allowed to refund. No, it's not allowed. He cannot be refunded.
Thank you very much po, sir. So for the next question, okay, I believe that was our last question. So if you have more questions, you may still ask them out by visiting slido.com. All you have to do is just type in the event code, um, hashtag government procurement PH, which the GPTSO will answer through an issuance or through FAQs. So at this point, we would like to thank you again, our resource speaker, Judge Anthony P. Vitor, for all the time accepting our invitation and for extensively and enthusiastically attending the concerns and questions raised by our participants on both our first and second learning session. And to our participants from both Zoom and Facebook and YouTube live streaming who actively participated all throughout the course of our program this week, we thank you all very much. Again, we would like to reiterate that our fourth learning session module on standard bidding procedures for goods, infrastructure projects, and consulting services will be held on August 30, Tuesday. So please make yourselves available on this date because we assure you that most of your concerns or questions to the conduct of bidding activities shall be addressed in this module. So also for our winners, again, congratulations, and please check your emails or chat box and kindly provide us the details needed for us to ship your special tokens. So now may we request everyone to please switch on their cameras to commemorate this learning session with our resource speaker. Okay, at the count of 3, we will be having 3 shots. Are we all ready? Can we open our cameras po? Huwag na po kayong mahiya. Okay? So at the count of 3, flash your biggest smiles. Okay. 1, 2, and 3. So on to our second shot. We have 1, 2, and 3. And for our third and last shot, we have 1, 2, and 3. Okay, thank you so much po for turning on your cameras. Kahit yung iba, alam ko, medyo shy sa camera. Thank you so much po. So before we proceed to the final reminders, allow me to provide a recap or bird's eye view for today's learning session. So for today's activity, we have an in-depth discussion regarding the highest form of ethics through the discussion of penal, civil, and administrative provision, highlighting its clause, offenses, penalty, and sanctions. So we also discussed the guidelines on the termination of contracts, also its grounds and procedures. On to our next learning session, we are reminded about protest mechanism and remedies, where we have learned the grounds and remedies of offenses committed in relation to the conduct and or participation to procurement activities and understand the procedures and considerations of how to resolve a request for consideration and or protest. So we also have understand the procedures on imposing administrative sanctions in the form of blacklisting to bidders who committed any of the violations during the competitive bidding or contract implementation stage. And gain substantial knowledge on the responsibility of the back secretariat, observers, bidders, and the end users or implementing units relative to the issuance and posting of the blacklisting order. Again, today's sessions are led by none other than Judge Anthony Vitor. Thank you so much, attorney, for accommodating us. So for the final important reminders, as part